So let me tell you about a man who spent 30 years fighting for one principle, just one, that your race should never determine your fate in America. He went to Princeton. He went to Penn Law. He worked his way through the Obama administration at the EEOC, through the Ford Foundation, through the NAACP Legal Defense Fund, not once, but twice. In January of 2025, he was named to the second highest position at the oldest and most powerful civil rights law organization in the country. He said publicly that the nation was at a critical moment for civil rights. He meant it. He'd spent 30 years preparing for exactly this fight. His name is Todd Cox. And on May 19, 2026, 3 weeks after the Supreme Court handed down the most consequential voting rights ruling in a generation, he sat down at a witness table before the Senate Judiciary Subcommittee on the Constitution. He was there to testify about a decision he believed had unleashed chaos. He had his testimony. He had his arguments. He had 30 years of civil rights law behind him. And then Senator John Kennedy stood up and asked him 13 words. Do you think race should be used to harm a person? 13 words, yes or no. And Todd Cox never said no. Here's what nobody is connecting right now. The reason Cox couldn't say no, the thing he didn't say in that hearing room, goes back to the day the organization he runs was born. And it's going to change how you see this entire debate, because this isn't just about Louisiana. It's about 15 states, congressional maps being redrawn this week, and a constitutional principle that decides who runs the House for the next decade. Let's get into it. Kennedy's been on the Senate Judiciary Committee for years, and he has a style. Bloomberg Law described it plainly. 15 lawyers sit on that committee, but Kennedy gets inside witnesses' heads like nobody else. Former law professor, Southern drawl, a Socratic method that sounds folksy right up until it doesn't. He's toppled judicial nominees, cornered administration lawyers, and made law professors squirm on national television. At the May 19th hearing, Cox had just delivered his opening statement. He told the subcommittee what he believes, and he wasn't wrong to believe it. He said that every day Black Americans feel the sting of racism in their lives. He said the Roberts Court has, his words, eviscerated the Voting Rights Act through Shelby County, Brnovich, and now Calais. He said Calais had unleashed chaos in the 2026 elections. He said the Supreme Court is pretending America has already achieved its highest ideals when it hasn't. That's been his position for 30 years. Then Kennedy stepped up. I don't mean to be rude. Do you think race should be used to harm a person? Simple question. Yes or no? Cox pushed back. He gave context. He explained the stakes. He was substantive. He never said no. Think about what that means. A man who has spent 30 years fighting the principle that race should determine Americans' fate, who testified in that very hearing that racism shapes the landscape of opportunity every single day, could not give a simple no to the question of whether race should harm people. Kennedy wasn't asking out of nowhere. He had a very specific reason for that question, one that connects directly to the case Cox was there to testify about. Because the 12 people who brought Calais to the Supreme Court were also Louisiana voters, and they also said race was being used to harm them. That story is more complicated than Cox's opening statement made it sound. But here's what makes it so much bigger, because what happened in Louisiana didn't start with that ruling, and what happened next is already reshaping maps in 15 states. To understand Kennedy's question, you need to understand how Louisiana's 6th congressional district got drawn. After the 2020 census, Louisiana redrew its 6 congressional districts. Black residents are more than 30% of the state's population. But the new map gave Black voters a realistic shot at electing their preferred candidate in only one of those 6 seats. The NAACP Legal Defense Fund, Cox's organization, sued. Robinson versus Landry. They argued Section 2 of the Voting Rights Act required a second majority Black district. The federal court agreed. Louisiana had to draw a new map, so Louisiana drew Senate Bill 8. It created the 6th Congressional District, a narrow corridor stretching 250 miles from Shreveport down to Baton Rouge, connecting majority black urban centers through rural parishes. It allowed a black Democrat, Cleo Fields, to win a congressional seat in 2024. Then, 12 Louisiana voters filed suit. They were not black. They argued race was used against them, that the state drew those lines with race as the predominant factor, harming them by making their racial identity a determining factor in their political representation. They won at the district court. Louisiana appealed. The Supreme Court took the case. April 29, 2026. 6-3. Justice Alito for the majority. The state had no compelling interest in sorting voters by race. The Equal Protection Clause prohibits it. Unconstitutional racial gerrymander. Cox's organization lost. The NAACP Legal Defense Fund, founded to fight the principle that government can sort Americans by race, spent 4 years in court defending the government's right to sort voters by race. 12 voters said you're using our race against us. They won 6-3. And when Kennedy asks Cox if race should be used to harm a person, he's asking about those 12 people. But here's where it gets deeper. Cox never mentioned the name that answers this question most definitively. Someone who settled this debate before Kennedy was born, before Cox was a lawyer, before this case was imaginable. And that name has been in the room this entire time. Before we get to that name, you need to understand what's already happening on the ground. Because Calais didn't just produce a hearing, it produced a congressman who lost his seat before his first term ended. Cleo Fields is a black Democrat from Baton Rouge. He represents Louisiana's 6th congressional district, the seat the LDF spent years fighting to create. When the Supreme Court ruled on April 29th, Louisiana Governor Jeff Landry issued an emergency order, mid-primary season, with mail-in ballots already sent, with early in-person voting already underway, postponing the state's congressional primaries. Louisiana had to draw new maps fast. The Louisiana Senate voted 4-3, straight party line, to dissolve Cleo Fields' majority black 6th district and replace it with a majority white Republican seat. Fields told a radio interviewer, "I won't be running for that district. Let's be clear on that. I have no desire, have no interest in running against Representative Carter." Gone. Before his first term finished. Here's what you need to know about Cleo Fields. This isn't the first time. In the 1990s, Fields held a different majority black Louisiana district. The Supreme Court struck that one down as a racial gerrymander in 1995. He fought his way back. He won a seat in 2024 under the new map. The court struck that seat down before he finished his first term. He is the only black congressman in modern history to have 2 separate congressional seats struck down by the Supreme Court as racial gerrymanders. 2 seats, 2 rulings, same man, same state. And Louisiana is the beginning. In Alabama, the Supreme Court vacated a court-ordered map on May 11th, a map with 2 black opportunity districts, and returned the case to a lower court to be reconsidered under Calais. Alabama immediately moved to reinstate a 2023 map that courts had previously ruled was discriminatory. South Carolina's governor called an emergency legislative session. Texas had already been operating under contested maps. Analysts at Issue 1 estimate 15 or more congressional districts could be gerrymandered under the new legal standard in time for the 2026 midterms. If those 15 seats move, Republican House control is effectively locked in for the next decade. So when Cox told that subcommittee Calais unleashed chaos, the consequences are real. What Kennedy's question was pointing to is whether the chaos was inevitable the moment the LDF's legal strategy collided with the organization's own founding principle. There's a man who could answer that. His name has been in the room this entire time. The NAACP Legal Defense Fund was founded in 1940 by Thurgood Marshall. You know the name. He became the first black justice on the Supreme Court. But before that, he was the most consequential civil rights litigator in American history. The case that proved it was Brown v. Board of Education, decided May 17, 1954. Marshall walked into the Supreme Court and argued a simple principle. The government cannot sort children by race, not for separate but equal schools, not for any reason. The 14th Amendment's Equal Protection Clause means what it says: equal protection for every person, regardless of race. 9-0. Marshall won, and the country changed. That principle, government cannot sort people by race, is the founding DNA of the NAACP Legal Defense Fund. It is the legal legacy of the man whose portrait hangs in Todd Cox's building. Now read this again. The 14th Amendment, the Equal Protection Clause. Our acceptance of race-based state action has been rare for a reason. That's Justice Alito, writing the Calais majority. April 29, 2026. The same amendment, the same clause, the same principle Marshall invoked in 1954. Applied to a map Cox's organization spent 4 years defending. Kennedy's 13-word question is Marshall's question. Should the government use race to sort people? Marshall said no in 1954, not for good reasons, not for benevolent purposes, not when Congress says it's required, no, never. And Cox is arguing that Congress's interpretation of the Voting Rights Act means yes. Sometimes the government must use race as the predominant factor, even if some voters are harmed, because the alternative harms different voters. Marshall built an organization to prove the government has no right to sort Americans by race. His organization is now in court arguing the government is required to. Kennedy sat across from the man who leads that organization and asked 13 words. The answer Thurgood Marshall gave in 1954 was still the right answer. Cox just couldn't say it. So here's what you now know that most people shouting about this case on cable news don't know. Todd Cox couldn't say no because the legal position his organization has defended requires the answer to sometimes be yes. 4 years of litigation. 4 years of briefs arguing that the government must use race as the predominant factor in drawing political lines. And when Kennedy asked the most basic civil rights question in America, should race be used to harm a person? The second highest officer of Thurgood Marshall's organization answered with context. Here's what all 4 pieces of this story say together. Kennedy's 13 words revealed a genuine constitutional fracture at the heart of the LDF's legal strategy. The Calais case shows the fracture runs all the way to the Supreme Court. The real-world damage. Cleo Fields losing his seat twice, 15 states redrawing maps this week, the 2026 House majority potentially decided before a vote is cast, is what that fracture costs in human terms. And the founding principle of Cox's own organization, established by Thurgood Marshall in 1954, is the answer Kennedy was asking Cox to give. Equal protection means equal. Not equal for some people depending on which side of the redistricting line you live on. Equal. That's what Marshall argued. That's what Kennedy asked. That's what Cox couldn't say. You now know something the commentators aren't telling you. Kennedy's question wasn't a trap. It was the founding principle of the organization Cox leads. And right now, in 15 states, the answer to that question is being drawn into maps that will shape who runs Congress for the next decade. If this opened something up for you, subscribe and turn on the notification bell. More breakdowns like this are coming. Drop a comment below. Should the Equal Protection Clause protect every American equally, regardless of race? Let's hear it. Todd Cox walked into that hearing room on May 19th representing an organization built on the principle that race should never sort Americans. Kennedy asked him 13 words. The answer Thurgood Marshall gave in 1954 was in that room. It just wasn't in Cox's response.